Hello, everyone. Welcome. Thanks so much for joining us today to discuss tips for achieving HR compliance. My name is Steph. I'm an HR partner here at Let's, and this is DeAnna Pillen, an outsourced HR specialist. For those of you that are not as familiar with Let's, we are a business solutions firm born and raised in Nebraska with offices in Omaha, Lincoln, and Grand Island. Over the years and working with clients, we've developed multiple divisions to serve clients, and DeAnna and I represent our outsourced HR offering. We offer support and HR solutions and strategy to small to mid-sized businesses. Our team can step in to be your HR team if you do not have an HR resource on site. We also help coach and provide support to HR team members that are maybe operating on their own, or you are the lucky person who is wearing the HR hat and needs a little assistance. We can assist. So much of our session today on HR compliance is based on the experiences we've had with our clients. We're looking forward to the discussion. All right, as far as our agenda goes, today our goal is to provide you with a high-level view of some important HR compliance items. These are items that you definitely want to make sure that you are in tune with. And based on the fact that we have an hour to cover some important topics, we will be covering them pretty high level and briefly, but please know that we can assist further if you have additional questions. And we'll try to save some time for questions at the end. If we don't, feel free to email us directly. Be happy to help answer them. And then just a side note that the PowerPoint recording and a brief survey will be sent to all of you tomorrow. So you will have those slides and they'll be available to you. All right, so when we're thinking about HR compliance, we're really talking about ensuring that your organization's policies and actions comply with federal and state labor laws and also industry-specific regulations. It involves everything from creating and documenting policies to making sure that you are consistently applying them. And being in compliance with HR labor laws could just ensure that we are providing a safe environment for employees. We are promoting fair labor practices, equal pay practices, and just making sure that we are preventing anything that may result in legal consequences. And many of our clients, this is probably the most immediate thing that people come to us with, some items on fire or things that are keeping them up at night. And the overwhelming quote that we tend to hear over and over is, I just don't know what I don't know. And that is very understandable. Staying on top of all of the HR legislation can be very tough. It can be nerve-wracking at times, especially if you are taking on a role in addition to your main role, or if you don't have a lot of background or training in HR. So we're here to help. Again, our goal is, I think we have 9 or 10 HR compliance topics, and just want to make sure that you're thinking about all of these as you proceed. So the first thing we want to suggest, and this is very general, but is staying informed about HR employment legislation that affects employers of your size and industry. And this is a list of some laws that, just as an example, some legislation that we would recommend that you are familiar with. And again, I should acknowledge we have a lot of different sizes of organizations on this call and a lot of people in different roles. So some of you may be very well versed with these laws, and some of you not so much. Something to point out is that we don't have to know every nook and cranny of the law, but enough to raise a flag. If you do feel like you're running into something that needs a little bit of a deeper consideration, that's the point where you can call on people like us or your employment attorney to help you navigate those laws a little further. Here's an example of what we're talking about when we're talking about making sure that you are aware of what laws affect you, depending on the number of employees that you have. So, for example, on the far left here, there are a number of laws that apply to all organizations, and please note that an inclusive list of all HR laws. These are some, important ones and things that we probably help clients navigate the most. But you can see that if you are a growing organization and a small organization reaching 15 plus people, there's another set of laws that apply to you. 20 people, another said 50, 100. So this really does require that you are on top of what affects you from a size standpoint. In addition, there are industry-specific legislation laws that affect you, as well as state-specific. And DeAnna, we're doing a lot of assistance with people that have remote employees in different states, and just trying to stay on top of all of that can be a lot. So I realize this is a very, general item, but just making sure you know what applies to you. And if you don't feel like you can handle that alone, for example, we offer a proactive compliance alert as part of our HR service. And we have also included some different resources on the last slide of this presentation. So if you do need to dig a little bit deeper and make sure that you understand these laws. So again, the point here is just that continuous review of legislation that affects you, especially if you're a growing organization. Another item we want to make sure you're in tune with is the employee handbook. As you are likely well aware, an employee handbook is a company resource that provides employees with information about expectations for working in your environment. And we want to encourage you to make sure that your employee handbook is clear and user-friendly and also reflects your culture. An employee handbook does not have to be full of all sorts of legal jargon. It doesn't have to be super formal or super informal. You can find a really good middle ground as long as it's clear. You really want people to read it. That's the important part. And it might not be the first thing everybody wants to read. So trying to make it clear can be very helpful. You'll also want to provide the employee handbook, of course, to any new hire. And we encourage you to take the time to discuss important policies to your organization during orientation. This is such a critical time to set expectations. We have noticed that, and we feel it ourselves sometimes, there are a lot of times that the clients we're working with are frustrated about people not meeting expectations. And so don't miss this opportunity to really be clear about what is expected. You'll also want to obtain signatures from your new hires, confirming receipt and review of the employee manual. This can be as simple as having an acknowledgement form at the end of your employee manual that they sign and turn in, or using DocuSign or something of that nature to make sure that they've acknowledged that they have read and understand what the expectations are. You also want to inform all of your employees about any updates and collect signatures to confirm receipt and review of changes. We recommend an annual review of the employee manual. And, we're not suggesting that for every tiny little change that you make throughout the year that you have to send something out and collect signatures. That would be a lot. But you can collect some of those minor things and changes that you make throughout the year and summarize those when you are communicating after your annual review. And, of course, any major changes that you have to the employee manual, we would encourage you to get that communication out in a timely manner. But as far as the signature, it doesn't have to be immediate. Do you have anything to add, DeAnna?
I was going to say, Steph, something else to add would be that there may be some language in the handbook that denotes that leadership can change verbiage or omit policies as they see fit. So giving yourself that legal leeway throughout the year to make changes as you see fit when things arise.
Yeah. If you are developing handbook for the first time, we do suggest that you have an employment attorney to review the handbook so you get off to a great start. The employee handbook is not, employers are not legally required to have a handbook, but we do encourage people to have one. The important thing to remember, though, is if you do have one, you're going to want to make sure that you are practicing what you have set out in the handbook versus doing something totally different. That would not be a good situation. So making sure you're consistent with your practices that you have laid out. Anything else you'd add on the handbook?
No.
Right. Very good.
Perfect. Moving right along to labor law posters. First and foremost, there are a set required amount of posters that are required from a federal perspective. So think like minimum wage, FMLA, things along those lines that are required to have posted in every office space and in an easily accessible employee-centric location. Our best suggestion is to review your labor law postings every year in January to make sure they are current and up to date. If you potentially are an employer that has employees that are remote or that are working within a different state, we highly suggest having these posted internally on some sort of electronic drive, like the intranet, Dropbox, or somewhere easily accessible to those remote employees that are in another state. State-by-state posters do tend to change far more frequently than the federal ones. So as Steph had mentioned, part of our services is staying aware of those changing applicable state laws per size, per geographical location that our clients have employees in. And something else that we would strongly suggest if you have a large or diverse population across the United States is considering a poster service. For example, another great resource that we've seen is Poster Guard, who will automatically mail you new labor law posters for state and federal every January as changes are made to keep you up to date in compliance for whatever state you may have remote employees. Yeah, no, perfect. Personnel files, moving right along. Something very important to be aware of is staying on top of your personnel files and how those are retained within the organization. First and foremost, we like to make a note that as you're reviewing your personnel files, making sure that your I-9s are kept entirely separate from the regular employee personnel files. We highly suggest keeping I-9s completely separate from an employee population, separate that are in a separate location away from the rest of the employees' files. In addition to that, if you have any employees that may have workers' comp information, health insurance information, anything along those lines that might have anything HIPAA related, this must also be kept in a separate file entirely from the regular employee personnel file that would have anything related to their work performance or anything along those lines. The normal employee personnel file must be able to be documents that are viewed by their direct management or supervisors, whereas anything that has HIPAA information needs to be kept strictly to a need-to-know basis, primarily HR or anyone in that health and safety realm for incidents or accidents. So making sure that those are separated in case there were ever to be an audit that can incur some hefty fines. So stay in compliance with that. As far as how you're retaining your personnel files, that's entirely up to the organization on what the best practice is. We've seen both. We don't really counsel one way or another. It depends business to business what makes the most sense. However, we do have a couple of different recommendations for making sure that you're staying in compliance for either route. If you are an organization that decides to do digital copies of your employee personnel files, ensure that they have adequate layers of security to protect them in the event of a cyber attack. In working with our tech group specifically, they've recommended features like multi-factor authentication and need-to-know basis. Also making sure that they are, if they are digital, that they're locked down to only pertinent individuals within the organization that can view them. You would not want to have all employees able to access all employees' personnel files where they might be keeping some bank records, social security cards, things like that. Just making sure that they're need-to-know basis only. And then as far as paper copies, something to have note is that you should have two methods of security protecting them in the event to prevent a breach. So our best recommendation for employers that keep paper copies is keeping them inside of a locked filing cabinet inside of a lockable room at the end of the day, just to make sure that no individuals that are unauthorized are able to view those. Perfect. Moving right along to the I-9 process. I-9s are an essential part of all employers. They're legally required across the United States, and all new employees of all businesses are legally required to complete these within 3 days of the employee starting work with the employer. So when an employee starts their first day of work, they're required to come in and present their documents, either list A or from list B and C, to complete the I-9 process. As I said, they have 3 days to complete this process, and if they are unable to do that within that time frame, they're unable to continue working. However, if you are able to utilize E-Verify to put them through the process and get a tentative non-confirmation, I would like to add that there is a separate grace period allowed to the employee to get the correct documents in place if a certain document is expired. So something to note there as well. If they're unable to do it within the 3 days and you use E-Verify, there is a separate process they can continue working until that is done and you've received a final confirmation of employment. Something recently added to the I-9 process after COVID-19 was the remote verification process. In 2021, they were able to add something to the process to allow employers to remotely review I-9 documents. So say your passport, driver's license, social security card, birth certificate, things of those nature were able to be inspected via a webcam with a proper HR representative reviewing those documents, provided that they were then later inspected in person by an August 2023 deadline. However, since they have now published a new I-9 form, they've removed that specific stipulation and changed this to that the employer must be enrolled into E-Verify and also put the new employee through E-Verify to be able to continue to do the remote verification process. So ensure that if you are utilizing that process, you are enrolled into E-Verify to stay in confirmation or in compliance, with those requirements for I-9 procedures. Additionally, as far as I-9 compliance and retention goes, there is a federally regulated time frame in which I-9s are retained for all employees, and we'll be diving into that a little deeper. Essentially, all current employees of your organization for the length of their active employment must have an I-9 on file. So from the time that they've been with the organization for 3 days, their entire length of employment, you must have a copy of their I-9 with the supporting documents. In addition, you must keep that I-9 for 3 years after the date of hire if terminated, or 1 year after the termination of the employee if that happens to be later than the 1 year minimum. And something else I would also like to note on the subject of I-9s is that although E-Verify is technically in Nebraska considered a voluntary participating program, in Nebraska, there are many other states that do actually require I-9s to go through E-Verify. Alabama, Arizona, Georgia, Massachusetts, Mississippi, North Carolina, South Carolina, Tennessee, and Utah. So if you have employees in those states, it is a legally required aspect to put all new hires through E-Verify with their I-9 documents. So for those multi-state employers, something to be aware of, especially.
All right. Another consideration as far as compliance is concerned is making sure to communicate and document performance discussions. We put this in the compliance tips because we run into a lot of situations with clients where they are frustrated and ready to terminate an employee. But in looking at whether there has been any feedback or documentation, if there is not any, it can be a tougher situation, and you could potentially run into some legal consequences. And although Nebraska is an at-will state, which DeAnna will touch on, it is a best practice to make sure that you have documentation of performance discussions to ensure that you are giving the employee a fair chance, and making sure that they have the time to act on feedback that you've provided. So a few reminders, because we hear these often, but they're difficult to do as humans. Giving feedback is not the easiest thing for a lot of people. So reminding yourself and your team to continue to provide specific and timely feedback. Do not wait until something becomes a major issue before you're giving the feedback. If you start to see something trending, make sure you address it. Consistency really is key when we're talking about giving feedback, and just making sure that it is a routine and a habit. And so one way of thinking about that is to adopt a coaching mindset. If we are coaching our employee, providing them with both positive praise and constructive feedback, that door will be open at all times, and nothing will be a surprise. There's nothing worse than sitting across from an employee when you're about to have a termination conversation and it is a surprise. That is definitely something we all want to avoid. Make sure to keep accurate records of your conversations. This does not have to be a book. It does not have to be overly lengthy. You just want to remember when you had the conversation and the nature of the conversation. Anything to add on that particular piece?
We've even seen some clients have a specific Word document that they save just to document any coaching conversations for performance improvement along the way, and just jot down a few quick sentences of when the conversation was had, what the overall feedback was, and that the employee received that feedback. So simple as easiest.
Yeah, it doesn't have to be anything formal, and it could go in a Word doc, as DeAnna said. It could go in your OneNote if that's where you keep notes, or on a notepad. I mean, in a secure place. But yes, just as long as you're doing that. It's very difficult to think back now. Did I have that conversation, and what did we talk about, and when was that? So really, you're not only doing the employee a favor by giving them a fair process and feedback, but you're doing yourself a favor, because if you do get to the point where you feel it's best to separate, you will feel good knowing that you did all you can to give the feedback, as well as know exactly how you did that. So stay objective and focus on the facts. I would say this applies to both when you are giving the feedback and when you're documenting the feedback. Make it about the performance, not the person. And then make sure to teach your managers and those that are giving feedback to both develop and hold your team members accountable. We're seeing a lot of this lately of, the pendulum has really been to one side as far as employees and us trying to do everything we can to keep them and motivate them and engage them and retain them. That doesn't mean we can't also set expectations for them. And so that is really important. We are seeing a lot of and helping a lot of clients with manager training and training their employees on how to have hard conversations, how to document those conversations. So we are available if that is of interest. So keeping these tips in mind can really ensure that you are providing your employee a fair practice, and you're also avoiding any potential issues. See that there, DeAnna? No? Okay. All right. Same goes with interviewing and interviewing questions. So this is a topic we have had a lot of discussion about with clients as well. How do we make sure we're giving the employee, or the candidate, a fair process, and also avoiding any pitfalls or potential discrimination? So again, a lot of these will be reminders to you, but making sure that you are putting a process in place to avoid discriminatory topics and staying within legal limits with the questions that you're asking and the process that you're implementing. Some of those topics, of course, include age, race, ethnicity, gender, sex, marital, family status, religion, disability, military service, financial status, pregnancy would be another one. So there's a lot of topics that we want to avoid, and so that we are not discriminating. The biggest thing to remember is just to focus on job requirements. A lot of those topics have nothing to do with the job. So as long as you are focused on what is required of the person to do the job, that is the most important thing to keep in mind. Making sure that you are consistent. We do encourage you to be consistent with the questions you're asking, but that does not mean that you have to be a robot in an interviewing situation. We'll talk a little bit about how you integrate compliance and culture, but that would be an example. You can have consistent questions, but you can still have follow-up questions to those that are tailored to the individual, depending on what the situation is or what you need to dig into, provided they are not on the discriminatory topic. So be thoughtful in your documentation as well. If you are taking notes on a resume or just taking notes in general, you want to be really careful about what you're writing down. For example, you do not want, if you're interviewing a lot of people, you would not want to indicate, well, yes, as a reminder to myself, this was the person who is the older candidate with, or anything about appearance or things of that nature. So stick to the facts. Stick to any job-related notes. That would be the best thing to think about there. Train your interviewers on what is legal or illegal to ask. We have a lot of candidates these days that are very in tune with what is legal and what are legal and illegal questions, but we don't always have interviewers that are in tune with that. So that's really important to make sure that you are training your interviewers and really understanding what they're asking. To be honest, oh, go ahead. Go ahead.
I would like to also add to that statement is training your managers on how to deal with volunteered information from the candidate. Specifically, if the candidate opens up and starts discussing, their age, their ethnicity, gender, sex, their family home life, their religion, knowing how to have managers take that information and move forward in a way that doesn't detract from the interview. And like Steph said, making sure not to make note of any of those volunteered information pieces on their resume. And that application, their resume must be kept on file for 1 year afterwards in case there were a potential discriminatory hiring claim. So paying very close attention to the notes you are taking, especially as it relates to that.
Great note. I think if there's anything else. We offer this type of training, but we highly encourage you. I think we have found that when we do the trainings, we run into a lot of people that say, oh, shoot, I've been asking those questions. So you may think that your interviewers are in tune with this, but again, the laws are always changing as well. So it only takes one situation to have some trouble in your hands. So, and again, we want to make sure that the candidate is having a really great experience too. There's nothing that will turn off a candidate more than to know they are being asked questions they shouldn't be asked. So,
absolutely. And I know one particular question that's come up more often than not in the interview process is asking about age in the hiring process and how that can be legal and how it can't. And we've been counseling a lot of clients on if there are job requirements that require a certain age, tailoring those age questions on what the specific requirements are of you must be 18 to work in this role. Is that something you're able to comply with? And if they say yes, you can move forward. So things like that, tailoring the question to get the information in a legal way as long as it's a job requirement.
Versus saying, what year did you graduate from high school?
Correct.
Or, trying to hint at how old someone is through a question that sounds somewhat legal is something that we have seen being done. So anyway, lots of things to think about when it comes to the interviewing process and the application process as well. Okay, we have some of you that are looking to receive CPE credit. So we're going to just take a quick pause and you must answer the polling question to receive the CPE credit. So here comes that question.
All right, everyone, welcome back. Thanks for filling that out. I wanted to continue today with going over at-will employment and what that means. Many of you are likely familiar with the statement of at-will being a very employer-friendly notion. However, there are certain instances where a statement can imply a contract of employment and lead to legal consequences. So first and foremost, we want to make sure that as you're looking over your hiring process, that you have some sort of verbiage in your offer letter that states something similar to this. Employment is at will and can be terminated by either party at any time with or without notice. And we also strongly suggest having this statement in your handbook as well on the acknowledgement section that the employee has to sign off on. But essentially setting the tone for the employment early and off the bat before they decide to come work at your organization, knowing that it is an at-will employment arrangement and this is not a contract of employment. We've run into issues where individuals have had their offer letter state an annualized salary, and this is potentially problematic because it implies 1 year's worth of salary intending for 1 year's worth of employment. There have been cases where employees have won this challenge in the judicial realm because of an annualized salary on their offer letters. We highly suggest using your normal monthly pay or biweekly amounts on your offer letters. If you want to include it in parentheses of what the annualized amount would contribute to be, that's all right, but we highly suggest having it separated out. And another piece with this is a verbal contract of employment. And this is where manager training becomes essentially very important. So I have been reading up on court cases most recently about managers who have made a statement to individuals saying things like, no one ever gets fired here. We've never had a layoff. You'll be here until you retire. However, a few months or a few years down the road, a layoff happens and the individual sues saying that they had a contract of employment based on that conversation and they have won these legal challenges. So very important to be aware of that. The penalties for breach of contract of a terminated party can be quite significant, including the legal costs associated with it as well. So just being sure you're protecting the company's bottom line from that as well. And like we said, making sure that managers are aware that statements like these, while they do sound nice, are not a good way to proceed in making sure that your company is covered from a compliance standpoint in avoiding a contract of employment arrangement unintentionally. So just being aware of that and having frontline managers know that is very important. Steph, anything you would add there?
Nope. Perfect.
One more thing here. So the ADA is known as the Americans with Disabilities Act, and many of you may know this, but a large part of the ADA is how Americans with disabilities are protected at work. And so we would like to cover how to stay in compliance for accommodating any employees that have a potential disability requiring accommodations. First and foremost, we should never assume that an employee has a specific disability. We should never be reaching out proactively to an employee of our organization and asking them, do you have a disability? That's the first thing that could land you into hot water if the employee was offended by this or they do have a disability and thought that they were being discriminated against. So we highly suggest that the employee should approach their direct supervisor or an HR representative and sit down and have a meeting first and foremost with their specific requests. And if applicable, they should be able to provide pertinent medical documentation as to what their disability is. We highly suggest never promising a specific accommodation during this conversation because that information, it's very important to take the information the employee has volunteered and given to you along with their medical documentation and taking it to the appropriate individuals such as an executive team, a leadership team, or someone that is able to review that to make sure that those accommodations for the individual are considered reasonable or not an undue hardship financially to the organization. And reasonable in this instance is subjective based on the ADA verbiage, and it differs by the business size. So what's considered an undue hardship for an employer with 15 employees is not the same as an employer with 15,000 employees. So doing your due diligence here and making sure that you are taking the employee's request during that interactive process discussion and being able to offer them an appropriate accommodation that's reasonable from the employer's standpoint. And if this is something where you feel you might be over your head a little bit, it's always smart to reach out to experts on this and say, is this a potential reasonable accommodation for this person's specific disability? I want to say that the amount of cases for this in the last few years have risen dramatically, I think by over 50%, with individuals looking for accommodations and not being granted them. And the amount of damages has been significant. So just being aware of what you can do from a culture perspective to help that employee and make sure that you're doing your due diligence with the Americans with Disabilities Act to ensure that you are being fair throughout that process and protecting the organizations as well.
I would add making sure to train your managers so that they know if an employee brings up something that could potentially be a disability that qualifies under the ADA, that they don't feel like they have to handle that alone, that they can bring that, like you kind of talked about, bringing that to the right people and being able to work through that interactive process, because that is a requirement that employers have, is to have that interactive process or conversation.
Something else I'd like to piggyback off of this, Steph, is that there was recently enacted the new Pregnant Workers Fairness Act, and they also mirrored a lot of their language off of the Americans with Disabilities Act for how the accommodations process works. That was mentioned earlier in the slides for compliance of employers with more than 15 employees in the United States, and that their process is very similar with the interactive process as well. And however, they consider the Pregnant Workers Fairness Act disabilities from that to be a temporary disability. So the reasonable accommodation is broadened a little bit more here. Since it is a temporary disability that would be ending after childbirth and return to work, they are much less stringent in this and require a lot more flexibility from the employer on this. So if that is a particular question that does come up with an employee, make sure that you're having that conversation and having productive conversations to make sure that you're being very fair to the employee throughout that process, as it is new and lots of litigation is just opening up on this one since it went into effect last year in June. So navigating some new waters there.
That's right. And the ADA, FMLA, so many of these laws have so many nuances to them, as all of you, I'm sure, are well aware of that. It definitely takes some reaching out to experts to navigate them and understand them. And again, just having a general idea of what the law is can help you understand when you need to train and how you need to train. So yeah, very good. I'm going to stay on this slide here for a second. So those are the compliance considerations that we help clients with a lot. But of course, there are so many other, compliance related questions, concerns, considerations, and so forth. So we're really just touching the surface on the compliance piece. The other piece that is hugely important to us is the culture piece. And I think that is where we really differentiate ourselves as well. Is how do you navigate all of these laws and still have an employee-friendly culture? Because there is so much to abide by. And let's be honest, HR folks and those of you on the call, we get a bad rap sometimes for trying to stay within all of these laws and, do our best to do our jobs there. So, the last thing we want to talk about is, recommending that you take a balanced approach to integrate both the compliance aspect of things and the culture side of things. So seeking to, again, maintain an employee-friendly culture within those legal requirements, that can be tricky sometimes, but let's take, for example, the handbook, making sure your handbook is clear and concise and easy to read, not overly full of information that people don't know how to digest, making sure it also includes items such as your vision and values and, things that are about your culture can be integrated into those documents as well. And that's an example of being able to integrate both compliance and culture. Things like interviewing questions, while you might be consistent in those questions, a lot of those questions can also integrate the culture side of things. So those are just a couple of examples of making sure that you are, again, working within legal limits. You're also considering what it feels like to be in the organization. Remembering that fair does not always mean treating people exactly the same. Sometimes, we can definitely be fair and still tailor to individuals, how they're motivated, what they need, what their circumstances are. We're not necessarily going to play favorites when we're tailoring. We can still have a fair environment, but we don't have to treat people exactly the same. We can work to align our compliance efforts when we do have cultural initiatives, making sure that we are reinforcing what we expect in terms of ethical conduct or behavior, and those two things can integrate there. And we always suggest to our clients that you ask yourself, what is the best compliance answer? And also, what is the best culture answer here? And if they line up, that's easy. So that's always nice. If those line up. If they don't line up, then you have a decision to make. What is the risk? What is the best, situation? Is there a middle ground somewhere in terms of how you can create a great culture in that particular moment or a culture moment, but still, have a low risk from a compliance situation? Anything else come to mind for you on this?
I just think of one particular client that we were working with where they had an instance where someone was wanting to utilize FMLA and they were an employer above 50 employees within that geographical location threshold. The employee had only been with the organization for 2 weeks shy of the required 1-year mark. And they came to us asking, what's the best process forward? They haven't quite met the requirements for FMLA, having been here for 12 consecutive months. What should we do moving forward? So we had a really good heart-to-heart discussion about this and what it looked like from the employee relations standpoint. So someone being 2 weeks shy of their 1-year anniversary to be able to utilize FMLA versus, denying the FMLA request and having them submit it again 2 weeks later, potentially. So, just making sure that we're being fair to the employee and we're also putting that culture piece in front of us as well. So we're able to take care of our employees and building that employer loyalty as well. So knowing that we did them a service for sure.
Thank you. That's great. I think for those of you that are in small organizations that maybe have a fear of becoming too corporate-y because of, all of these legal requirements, and trust us, as we've grown here at Lutz, we've always wanted to have that family feel and employee first mentality. And there are definitely ways to find a great middle ground and still, have a fair process and still abide by all of the legalities that we have to navigate around. So that is our last piece of advice on the HR compliance side of things. We do have a number of compliance resources we wanted to list. I'm sure you're familiar with many of these, but if not, these are some great resources. Again, not an all-inclusive list of places you can find some of the information that we had. So, one other reminder is just that compliance is a continuous process. It's not one of those things you can just check off your list and be done with. It is something that you have to continuously review, as you are well aware of, especially if you are a growing organization. And, something we always have to keep our eye on as HR legislation is constantly changing. So any other final comments? All good. Okay. So we hope that you have found at least one or two tips or reminders that you can focus on. We do have a few questions that are in the chat that we are happy to answer. What do you say? Okay, yes. So
first question here is, where is a good place to start if you don't have an employee handbook? I would say first and foremost, if you don't have an existing employee handbook, that you should start by seeing if you have any already defined policies and procedures that you are doing and seeing what a good employee handbook should contain and supplementing your materials in there, and then working forward to build out those other policies that you may not currently have but need to get in place.
We've seen some really, really small employers, so under 10, just starting with 5 important policies that they have, or if the legislation that applies to all employers, you might start with those too, and then just continue to build as you go. And even if you are small, and some of you are some of you might just be your family in the organization, so you think, well, we don't really need this. But as you grow, and it's very helpful to be proactive and make sure that you have a good starting point for the employee manual.
How can an employer go about finding out if employees have any medical conditions that our first aid and CPR certified employees should need to know about? Example, allergic to bee stings, diabetic. Well, I would first and foremost say we never want to ask someone directly if they have any medical conditions, just out of the interest of HIPAA and privacy. I would first start out by having all employees fill out an emergency contact form, who could be contacted in the event of an emergency, and maybe even having a secondary person to call as well. So if something does happen to an individual and they're unconscious or need CPR, you have an individual that knows their medical history that you could reach out to get that pertinent information in the event of an emergency. I wouldn't recommend keeping any of their medical conditions on file within the organization at all. Anything to add, Steph?
And if I think that an allergy is important to someone, I think they may volunteer that hopefully as well. So I have my managers send me an email on any performance talks or issues outside of the performance review. Does an email work for documentation? Absolutely. Yes, that's a great way, Carrie, to make sure that you have an understanding of what's going on and records. So.
What is best practice for small organizations regarding FMLA? By this question, I'm assuming that your threshold is under the 50 employee mark, and so that is not something you're legally upheld to. However, I would suggest evaluating that from a culture standpoint. We have a few different clients of ours in particular that are under that 50 employee threshold, and they have a leave of absence per se that they allow other employees to take. It's not necessarily a full 12 weeks, but it's something that they entitled their employees to use in the event of a sick parent, sick child, parental leave, something of that sort, just that they're allowing their employees some extra time, and then that they do have a job to return to after that leave. And they're very good at setting a specific time limit of what they can reasonably accommodate for that. So FMLA being federal and being 12 weeks, but just finding that balance between culture and compliance.
Yep. And to be competitive too.
Absolutely.
Right? To be competitive with other organizations that are a little larger, considering what to do from a time off standpoint. Yeah. Can you ask what are your hobbies when you interview?
Yes.
I would say yes too.
Absolutely. Yeah. Just be aware that they may volunteer something that you don't necessarily want to know.
Yep.
Whether they volunteer at their church, they have children, they spend their summers out in the dugouts watching their son play t-ball. Whatever it may be, being able to get back onto course for job related things, to make sure that there's no discrimination in the hiring process. We always recommend there's plenty of time to get to know them once they're hired as well.
Exactly.
We don't want to, make it a very cold and unfriendly process. I think what are your hobbies is definitely an okay question, but lots of time to get to know them once they've started.
Yeah, don't go down the rabbit hole. If they do mention something that is within the topic, right? Yes. Do you know that one?
How long should workers' comp files be kept? Don't quote me on this, but I believe the last time that I looked into this, the legal requirement was around 7 years. I'll have to do some more digging, but I'd be happy to get back to you on that specific question, Sylvia.
Kathy asked, do you give a temporary intern the handbook? They are not eligible for PTO, holiday, etc. benefits. We do have them sign an intern agreement, which states this is a temporary at-will position. I'll speak for us. We do give the the intern the handbook. One of the biggest reasons is we are hopeful that many of our interns will join us from a full-time standpoint. And so we want them to understand what our culture is about, what our expectations are, all of those things. And a lot of it, for us at least, does apply to them. Like you're doing, though, we do make it pretty clear that an intern is a temporary at-will employee. And so all of the benefits that are listed, the PTO, all of those things, it very clearly states that those are for full-time, regular, or part-time employees.
As for fair, not the same, using working from home as an example, do we need to offer working from home to all office staff of 7 employees? I-9 question. Oh, separate. So first and foremost, fair, not the same. I know for a fact that we have a client that has they're largely a remote employer, but they do have a few employees that are required to staff their home office on site for, I want to say, 25 to 30 hours a week. So they do offer some flexible arrangements to those staff members to work from home 1 or 2 days a week, but by and large, they're predominantly in office when 90% of the other staff is fully remote and geographically spread. So understanding that it's a condition or a function of their job to be on site, to be able to answer phones or get mail, something like that, or do the accounting and bookkeeping from an on-site perspective.
Yeah, and I would just specifically indicate in your policy that some positions are eligible for remote work and some are not. You know, a receptionist, that's really hard to do from home. And so, like you said, people that need to kind of be in the office. But perhaps there's something special you could do for the receptionist, similar to what DeAnna was saying. So,
Yeah, next question. I-9 question. An employee was just hired and we found several employees do not have I-9s on file. The total employees around 100. We'll be asking for I-9s from currently hired employees. What dates do we use on the I-9s? So going back to our conversation on the I-9s and compliance here, our best recommendation is to make sure that when you are filling out those I-9s for employees, you don't have copies of active employees, use today's date. Make sure that you're making a note on their I-9 that by some error, the original copy was lost and you are doing your due diligence to make sure that you have a copy of their I-9 on file. We found that other employers have had this happen before, and just making sure that you are practicing in good faith and fair dealing to make sure that you are having all your compliance documents in a row is very important. And that if you were ever audited, you would be able to pull those documents and state why they were missing, that they were then completed later, just to make sure that you're having an effort to stay in compliance there. So it's very slim chances that you are audited, but good to make sure that you have them for sure.
if we do not read your question, it's because we are going to get back to you on the question. We might not, there's a couple questions on paperwork retention, and just to make sure that we have all of those nailed down. We'd be happy to reach out to you. Go ahead. I think so.
Can you require managers to work more days in office versus staff? Example, managers 2 days and staff 1 day only. Steph?
I would say yes, if you have a good business reason for doing so.
Absolutely.
How would you try to persuade your managers to make some of these changes? How can I explain the importance of these changes? And I'm reading that as maybe some of the training on the legal requirements, interviewing, or things of that nature. How would you try to persuade your managers? Well, I think one is just the education of, do they actually know what laws, that are required for you as an employer? And also, there's a lot of ways when we pay attention to these laws, like for example, the documentation of feedback, that they can help. They're going to be helping themselves in addition to the employee by making it a better process for them. They will have for example, on the topic of feedback, they will not have as hard of a conversation at the end if they have given their feedback up until that point, just as an example. So I think one, educating them on it, and two, just making sure that they just have a thorough understanding, but also kind of what we were saying about compliance and culture. This does not always need to be a rigid change. Absolutely. There are ways that you can make this manageable and middle ground like. And we did have one client say, sometimes you just need to bring in a third party to tell them why it's important. And we have to do the same thing sometimes here at LUTZ, so.
How do you handle I-9 requirements for acquired employees? From my experience, there's 2 ways you can go about this. First and foremost, you can take the I-9 documents from the acquired company and incorporate them into your employee personnel I-9 files. Or I've seen other companies have them complete brand new I-9s for the new organization. So I've seen both ways. As long as you're having a copy of their I-9 documents, you are squared away and in compliance with USCIS requirements.
Take a couple more here. Do you have any suggestions for compliance in relation to job description?
I would say reviewing them specifically for actually required competencies, so to speak, making sure that the things that are listed on the job description are actually accurate depictions of what they need to be doing day in and day out, making sure that there's nothing that's gendered on them that suggests one gender would be able to do the position better. I've seen that in a few different roles. And then just, yeah, consistency throughout the different postings.
What are some ideas to get the owner to have different summer hours for staff?
Employee engagement surveys, giving feedback of what they would appreciate. I know in particular, we've helped other organizations with employee engagement surveys to go over what they value. And if the employee population said that they really valued more flexibility, or, you know, during the slow seasons, having fewer hours over higher compensation and wages, they were able to leverage that to improve their employee engagement. So just being aware of what the staff attitudes and feelings are, and being able to tailor the workplace to that from a culture and compliance standpoint.
Really thinking about why. Why do you really want to do that? Is it because you are looking to retain? Do you have a retention challenge? Do you have a challenge getting new folks to your organization? You know, really understanding the why and the business reason behind it, I think, is the way to educate an owner, or, you know, tying it to the business reason would be important. Okay, we'll take this last one. Great questions, everybody. Do you have any suggestions for electronic file storage outside of the company OneDrive files? What I specifically do.
I don't believe I have any specific. I'm not necessarily the largest tech person. I've seen other organizations work with their tech teams to find other solutions that require multi-factor authentication, but never dug through and actually implemented that specific file storage for them.
So if we learn of any, we can keep the chat. Okay, so I think we're going to wrap up. And you know, we appreciate all the questions. I'm glad we actually had some time, so that's great. Let's see, can you forward that next one, Holly? There you go. All right, so you know, we just want to thank all of you. We had a really great showing on this webinar today. Thank you. If we can be of any assistance from an HR standpoint, we would love that opportunity. For small to mid-sized companies, we do offer a complimentary HR assessment where we can take a look at what you have going on and see if there's any support that we might be able to offer you to enhance your HR strategy. So that's an option. Here's the Let's Network. As we mentioned, we have a lot of different services to provide our clients: accounting, consulting, financial, mergers and acquisitions, talent, and technology. So if we can be ever of any assistance, we would appreciate you reaching out. Thank you so much. Hope you have a great day. Good luck with your HR compliance. Thanks.